Good afternoon, people. This Clarissa Williams coming back at you. The last video I posted on Judge Rochelle Conits is called Segment 1. This is going to be segment number 2 as I dissect Judge Rochelle Conits' probable cause order that's full of lies. It's a falsified court order. And let me say this. I'm here because I'm a whistleblower. I'm blowing a whistle on Greenville County Department of Social Services and Greenville County Family Court judges. This is to help families who have had their children taken, or these agencies have come in your life for whatever the reason is. So I just want you to know that they are not following the rule of law over there. They're not, and nobody's monitoring them, and nobody stops them when they stops DSS when they break the law. That's the judge's responsibility. The judges are the only individuals who can issue a court order. They have to stop these people when they break the law. They're not doing that. And they're allowing DSS to terrorize families, destroy them, ruin your livelihood by putting your name in that database. And some of y'all names shouldn't even be in that database because you ain't done nothing to those kids. And they are using ex parte orders to take children. That's a way that you're not going to be there. And they get it signed, they just snatch your child. But I don't understand, if all these documents are falsified, how are you putting cases on the docket? Let me stop, because some of them ain't even on the docket. And I'm going to show you with this prime example with this Judge Rochelle Conits. So we're going to pick back up because the last one I left off on number 12. So now I told you I got my little notes, and that was Angelica. So it was about appearances were listed as above. They didn't have her name listed. I show that to you. It usually will say defendant's attorney. It's not there, but they listed her right here. That should be attorney Angelica Hernandez. So let's go to number 14. Defendants. Clarissa Williams was served with the pleadings in court by the deputy. Now this is important because you have to serve a person a notice so they'll know why they're going to court, what the allegations are, or they need to know what's going on. So let me show you Sam Weldon, the main criminal over there. He's a managing attorney. He gonna lose his job. I'm gonna do everything within my power to get that man put in handcuffs. Because this is a shame. And I know, Michael Leach, you got to know what's going on over there. You got to. So let's go right here. I'm gonna show you something. Now this is what he filed. It's a summons, notice of hearing, right to counsel. Okay, it says you are hereby summoned and required to answer the complaint in this action. It says you are further notified and summoned to appear. Look, 72-hour probable cause hearing will be held on December the 15th at 2 o'clock. Now he filed this on December the 14th at 1:12, the day before the hearing. Now, I just showed you where he said he served it to me in court. So that means he didn't even serve me this document, and he didn't serve it to me in court. He served it to me after, listen to this, after the hearing. Did you hear that? After the hearing. So you didn't even, that's why when I went to court, I had no idea why I was going to court. See, this is what they should have gave me, this complaint. This is a complaint. They didn't give it to me. All they gave me, once again, is this little document from Judge Terry Dunbar, like this. Didn't have no cover sheet or nothing with. This all it said. It came before you. The plaintiff alleges probable cause exists. Don't say what kind of probable cause. Plaintiff has submitted sworn affidavit. Don't say nothing. No facts in this thing. Like I told you, they just changed the child's name, parent's name, keep rolling. Just a standard document. Okay? So let's get back. Like I said, I wasn't properly served. If so, I would have been prepared, but I wasn't prepared. Okay. So DSS denied me my right to due process again because you concealed these documents from me. And the proof is right here. You said you served it to me in court, but you didn't say you served it to me after court, because if that was the case, my attorney Angelica Hernandez would have been able to argue about everything that was in there. So you didn't even do your job. So let's go back. Okay, I want you to see this. Let's see. I got a page 24 on the transcript, baby. 24. It says, what line numbers? 22 through 25. Okay. Look, okay. So this is the transcript. Okay. So she's let me see. Okay. Judge Conits was gonna let me give testimony, but she changed her mind. So let's go right here. And see, I didn't even get to submit affidavits. I was supposed to be able to submit affidavits saying, giving my side of the story and why I felt like my daughter should not have been taken from me. I didn't get to do that. We're going to get into that. Judge Conits wouldn't let me do it. But okay, I'm just going to show you that they didn't serve me. Here's my attorney. I had to get that lady that morning, December 15th morning, because I didn't know why I was going to court. And she asked me, and I kind of felt ridiculous, but that's all they gave me. Okay, here go Miss Hernandez. Your Honor, she was just served with those papers yesterday. That was the 14th. She didn't even have 72 hours to prepare for this hearing. She came to her office this morning. We went through the papers that she had. This is attorney. She didn't even have the full packet with her because they only served her with a date for the day. That was the ex parte order. That's it. Telling me I had to be in court. This all they served me with. I'm gonna show you Judge Tarita Dunbar's. That's it. Find it real quick. That's all I had. Like I said, I ain't know I was going in that courtroom. I ain't know nothing. That's it. That's all Haley Rogers' hand gave me. December 15th. And walked off, said, be in court tomorrow. I ain't even, like she said, I ain't even have the address. She said, they didn't even give her the address of where she needed to be. And that's why I came to represent her. But she was actually not given enough time to prepare or myself to prepare for this. Did you see that? This how they do you. This how they do you. Now, that's the transcript, okay? So you know I ain't lying. Okay, we're going to keep rolling. I told you, this thing is serious right here. Okay, so let's keep rolling. So, you didn't even properly serve me. Number 14. Number 15, based on... Oh, and let me go back and read this to you. I'm going to come back to that one. So, we're gonna stay at 15. Based on examination of the file and the pleadings, she checked that, and recommendations of the guardian ad litem, I find that South Carolina Social Services has made a prima facie. Let me go. Okay. Based on the evidence presented by DSS that returning a minor child to the home will be seriously endanger the child's physical safety or emotional well-being. So let's go back to 15 and 16. Upon an examination of the file and pleading. So let's go to number 15. Got my little notes over here. Okay, she said, based on the file, so you read the file, Judge Conits, right? Okay, so let's go back. So we're going to go back to page 4, line 5 through 8. Show you. I told them judges be coming out, they don't know what's going on. Okay, page 4, transcript. Here we go, Clarissa Williams, December 15th, Judge Conits. Okay, because y'all need to know, this is some serious business. Okay, that's it, page 4. Line 5 through 8. Matter set on my docket for an emergency protective custody petition. Yes, ma'am. A probable cause hearing. Now, she said for an emergency protective custody. He said yes. You said yes. That should have been a no. A probable cause hearing. And then here goes Judge Conits. Oh, I mean a probable cause hearing. Okay. No, I tell you, they don't know what's going on over there. And he lied because he talking about yes. Okay, so let's keep rolling, y'all. We done called them again. I'm gonna keep catching these people. This is absolutely horrible. Okay, so we're gonna keep rolling. Number 17. I make the following findings based on the prima facie showing required by South Carolina Section Code 63-7-710. And having heard the witness presented by DSS, that was Haley Rogers, the liar. That's the only that lady is a liar, and I proved it over and over. And having allowed respondents to submit affidavits and to cross-examine the department witness as to whether probable cause existed to effect emergency removal. Having allowed respondents to submit any affidavits. Okay, that's why Sam Weldon concealed the summons and hearing document from me. He concealed this because had I known that I could have prepared affidavits, I would have been ready to tear them up, me and my attorney. Now, I'm going to show you where that says. Okay, let me find it. Let me find it real quick. Okay, here you go, right here. December 15th. You may submit affidavits regarding the facts which are alleged to form the basis of the removal and cross-examine DSS witnesses. They ain't had nobody but Haley. That's it. That's the only person they had in that courtroom. As to whether probable cause existed to effect emergency removal. You can request the appointment of an attorney at this hearing. See, I didn't even know that. You just read it. You may submit affidavits regarding the facts which are alleged. See, he denied me my right to due process because he knew if I had submitted those affidavits, my baby was coming back home that day. This is criminal right here. Now, it said that I could present affidavits right here in her court order. And having allowed respondents to submit any affidavits and to cross-examine. That's what she said right there. Number 17. So I'm going to show you. Read to you. That's not true. She didn't give me an opportunity to present anything. Okay, so let's hit it. So let's go. Page 24. Let's go to the transcript again. This is so serious. This is so serious. That's why I'm showing this. This is so serious right here. Highlight this. Give me a minute. I'm sorry, y'all. Okay, so we're going to go to page 24. See, I want the Supreme Court to see this. And all my general legislators. And the United States Attorney General, South Carolina Attorney General, SLED, FBI. This is real. This is real up in that courthouse. It seemed like a movie. My girlfriend said, this is just a Lifetime movie. Okay, so we're going to page 24, line 22 through 25. Okay. Ms. Hernandez, Your Honor, she was just served with those papers. She didn't have time to prepare for this. We went through the papers. Okay, so we're going to go on down to line 24. I'm sorry, page 25, 1 through 6. She didn't have the full packet with her. Okay, I can't represent her. We're going to go on down. Okay, here we go, right here, the court. See, saying, well, didn't want me to do them affidavits because she was going to let me testify. The statute is clear about the only testimony allowed from defendants is by affidavit, and they're allowed to cross-examine the department's witness. This is only a probable cause hearing. It's not a merits. And here goes Judge Conits. Yeah, and I'll tell you what. Since we have to another probable cause hearing anyway, when the father gets served. If she wants to be heard at that with her affidavit, I'll allow her to do that. Okay? So she didn't allow me to present affidavits. She said she let me do it when the father, if she wants to be heard at that with her affidavit. Now, she knew there was a possibility that she was not going to be the next judge that was going to be at that hearing. She knew that because the next judge I saw was Catherine Tiffany. So she denied me my right to due process. Okay, so she said she had probable cause to keep my daughter. She didn't have nothing but Haley witness statement. That's it. Her and Sam Wells. And as you see, they done lied throughout this whole transcript and this court order full of lies. So you see that? Now, you see, I just showed it to you. She said, and having allowed respondents to submit any affidavits. No, you didn't allow me that. You denied me that right, Judge Conits. And since I'll tell you what, since we have to look at that, and again, the statute is clear about affidavit, another probable cause. And then it says, probable cause to keep the child in the care until the next probable cause hearing with the father, at which time, if she wishes to present, this is on this next page, affidavits, the court will allow her to do that at the next hearing. Did you hear that? With the father. At which time, if she wishes to probable cause to keep the child until the next probable cause hearing with the father. Did you see that? At which time, if she wishes, you should have let me. You should have let me write that affidavit, and since we Sam Weld and the DSS conceal the summons and hearing, write the counsel document. Okay, y'all, let's keep going. We're gonna keep going because I told you these people have committed crimes against me and my daughter. Okay, so that was number 17. Number 17, 18. There was probable cause for law enforcement. Now they put and or the court. Did you see that? Now, see, that's a deceptive tactic right there. First, you said law enforcement in the beginning. You said law enforcement remove this child. Custody removal by law enforcement. Now, you done flip back over and forgot your little lie you told. And now you put a slash of the law enforcement or the court to take emergency protective custody, and for South Carolina Department of Social Services to assume legal custody of the child. And then you said, based on testimony and or evidence presented by the plaintiff, you said presented by the plaintiff, the allegations set forth in the plaintiff's complaint, probable cause to retain custody remains at this time because there has not been a material or substantial change in circumstances with the parties since the EPC of the minor child occurred, and no appropriate alternative placement for the children has yet been located. Has yet been located, y'all. Okay, so, this is a mess here. Okay. And now this is the court order that she signed after December the 15th. Okay, so we're gonna go read this, okay? Because my aunt was at that hearing, and my aunt wanted my daughter to be placed with her. So we're gonna go back to that transcript. This, I'm telling you, this is straight down. Judge kind of signature on this thing. I'm gonna show it to you too. This is evidence. This is no lie. This page 12. I got line 16 through 25. All right. Now, since the child is coming to care, did you have spoken, mother, about potential relatives for possible placement of the child? Briefly, yes. This is Haley now. And that's a lie. I done showed y'all all those documents from that lady where she said, first she said, I didn't have any relatives here. Then she came back on a reasonable efforts affidavit and said DSS had no knowledge of the family prior to the removal of the child. Then in the complaint, she said, I refused to provide her. Let me see if I cross it out. If I didn't cross out the names on it, you can't see it yet. Let me see. I'm going to let you see it real quick. Let me see. Look at this. Due to Clarissa not complying with DSS and refusing to name a potential caregiver for the child, DSS has concerns. I'll get some concerns. You ain't say nothing about what did I do. What kind of concerns you have for her safety? Because I do, Lord have mercy. And even if someone did refuse to give you information about a relative, you still got to have evidence and facts of what you're saying. They may not want to work with you because they know what I know. You're liars and you're criminals. Look at that. Due to Clarissa not complying with DSS and refusing to name a potential caregiver. Now, this is the summons. Let's get it. Look, let's cover sheet. This is the summons, so y'all can stay with me. Summons, notice of hearing, right to counsel. Okay. Saying well to sign that. This is the complaint. Saying well to sign on December 14th. Okay, you said you didn't know me in this complaint. Now you come back over here. Lord have mercy. Then y'all come back over here and y'all say that you didn't, no appropriate alternative placement for the children has yet been located. But then on the 15th, when we in court at the probable cause hearing, this Haley comes back and say, she gave me the name of an aunt, a great aunt. I have it written. You ain't have nothing written down, honey child, because you ain't never asked me to give you nothing. Okay. It says, is that potentially this lady that's here with us today? My aunt was there. She wanted the baby. Yes, sir. All right. Okay. So you a liar. You could have placed my baby right with my aunt that she had a very close, loving relationship with, and she asked the guardian ad litem to place her with my aunt. So she'd rather go with my aunt. They said, no, you can't go there because my aunt knew what they did was wrong. Then they said, my daughter asked to be, she said, well, I'd rather stay with the foster mom than to go live with my dad. It's in the case dictation notes. Go read them. It's there. DSS case dictation notes. So that's a lie. They could have placed my baby right here. She could have stayed right in South Carolina. My aunt has been on, she's a retired from the AT&T. She worked over 25 years. She's been in her house over 40 years. She has never been arrested. She doesn't have a criminal background. DSS placed another family member with her in the past. My aunt is a pillar of the community. She's the matriarch of our family, and she's a good, loving woman. Okay, so we're going to keep going. Number 21. Now look, now this is this is about to get ugly now. The plaintiff made the following efforts to prevent removal of the minor child. Now I'm going to tell you again. DSS got to make some efforts. to whatever, they got to do whatever they can that's reasonable not to take that child. Give you parenting classes, place the baby with somebody, let somebody go to the doctor with you, make sure your house is clean. They got to do something. With me, I never knew I was under investigation. I never knew these people was considering taking my baby from me. When they realized they didn't do they never did an investigation. Only thing that's on that determination fact sheet is a type. They just type what Dr. John Melville put in his abuse and neglect report. They never talked to that man. They just typed it up and put it in there. They don't have not one witness on that determination fact sheet. They just said what he said. And he said that was his opinion. That man ain't never seen my daughter, met my daughter, examined her, treated her. I don't even know where the heck he came from. They ain't do their job. So when they realized they went over 45 days and they tried this little ex parte trick and started falsifying documents, they didn't think I was going to catch them. It was time for you to be exposed. Okay, so look, this is the crazy part. The following efforts to prevent removal of the minor child. Okay, so number 3, that's where we start. It's not checked. Okay, so it says or. So you go to number 3 or you go down or. So we're going down here because that's not checked. Now listen at this. DSS had prior knowledge of this family. Now they saying they had knowledge of us. Because remember it says, however, DSS was not aware of this particular incident. And then it says, look, this is crazy. The services made available to the family. Okay, my camera acting up. Before DSS assumed legal custody were the services made available to the family. See paragraph number 3 above. The services made. Number 3 not checked. So that don't apply. Can't even check. Then we'll go to 24. Let me get my little paper out. Lord have mercy, y'all. This is a disaster. So we're gonna go to number 24, y'all. The plaintiff, okay, so let's go to 24. The plaintiff made the following efforts to provide these services. Okay, look at that. The plaintiff made the following efforts to provide these services. See paragraph 3 above. It's not checked. Remember, you got to check this or you got to check these. That don't even apply because it's not checked. Okay, man, the following efforts to provide these services. They ain't make they didn't offer no services. They offer no services, y'all remember that? They ain't offer us no services. Sure didn't. Okay, now we're going to 25. See, the efforts did not eliminate the need for DSS to assume the efforts. Now, they just said they ain't make no efforts to assume legal custody because, see paragraph 3, it's blank. Ain't nothing there. And it says that a meeting was convened as required. That's the preliminary investigation. 63-7-640. That's they got to have that within 24 hours after taking your baby. So they took her on December the 14th. So the next day would be December the 15th. You know we couldn't have had that. That's impossible. And let me see if I can find it to you real quick. That's impossible because I was in Judge Conits' courtroom in 24 hours. I had to be there December the 15th. Remember at 2 o'clock? Remember that, y'all? So it says 63 what did it say, 740? 740, y'all. 740. Did it say 7? Let's see which one it said. Lord have mercy, 640. These people, they too much. This is a crime shame. It is like a Lifetime movie. Every time my friends tell somebody about this or an attorney that they know, they can't believe it. Preliminary investigation. The department should conduct within 24 hours after the child is taken in emergency protective custody. And it's going to talk about that meeting. If possible, at this time, if possible, the department, if possible, shall convene a meeting with the child's parents or guardian, extended family, and other relevant persons to discuss the family problems that led to the intervention and possible corrective actions, including placement of the child. So that would have been done on December the 15th, but I didn't have it because I was in court with Judge Rochelle Conits. So you know that's a lie. They didn't do no preliminary investigation with me having a meeting telling me why they took my baby. They just took her and bounced on me. Okay, so the meeting was conveyed. Now they just said the meeting was conveyed as required by 63-7-640. The persons present and the outcome or the reason for the meeting. Now look, now they just checked it was convened. Then they say, or the reason for the meeting not being held are stated in D3. That's D3. Now it's checked there. Well, the reason for not holding is nothing there, which is incorporated and attached in here too. Then it says, Lord have mercy. DSS made the following efforts to place the children with a relative known to the child or in another family familiar environment. They say they made the efforts. DSS should make reasonable efforts. Now they saying they shall make. Now they said DSS made the following efforts. This is a deceptive. This court order. This need to go to the FBI. DSS shall make reasonable efforts to place the children with a suitable alternative caregiver within a suitable time frame. Now look at that. On another one, this should make reasonable efforts. Okay. Lord have mercy. Then we're going to jot down number 28. The efforts described above were reasonable and realistic under the circumstances, and other services would not have allowed the children to remain safely in the home because of the circumstances of the plaintiff's first contact with the children. First time you talked to my daughter, she told you she was sick, and she told you she was living a good life at home. All her needs were being met. That's in another video. That's in DSS case dictation notes when Haley Rogers interviewed my daughter on November the 3rd, 2021 at that Taco Bell restaurant. Go get the dictation notes. Okay? Now look at that. Then it says these circumstances were as follows as set forth in the complaint. Complaint don't say nothing. These efforts above describe what efforts? You ain't make nothing. You ain't said nothing about what you did. You kept saying you didn't do them. Then you change up saying and or. What did you do? You ain't mentioned one thing, the efforts that you made. And then number 3 ain't even checked, but it says the plaintiff made the following efforts to prevent removal of the minor child. You said no services were offered at the time of the removal. DSS had no prior knowledge of this family prior to the removal of the children. You see, keep saying go back to number 3, but number 3, you said no services were offered. Then you put the word or, then you say come down here. And then you say DSS had prior knowledge of this family. Okay, see, I told you then I got so comfortable. Okay, then it says, I also found that continuation of the children in the home is contrary to the welfare of the children. And then it goes down here. It is, therefore, it is ordered. Let me catch up with my little notes and stuff. Lord have mercy. I'm going to stop in a minute. I think it's time to stop. I'm going to take a quick break from this. Lord have mercy. We're gonna stop at number 30 because this is gonna get real deep. But this is a mess. You can tell they don't care about no judges and no laws and nothing. Look at this. This is a disaster. Now you know you can't go to a real courthouse with some real judges and real attorneys that follow the law. And with this is terrible record keeping. It's a botched court order, a botched investigation. The meeting was recorded. Look, was conveyed as required. The person's present and the outcome for the or the reason. You put a check and said it was conveyed. Oh, my Lord, look at this. This is how they take your kids. They kidnapping children and with these documents, and ain't nobody stopping them. Like you ain't gonna tell me Michael Leach don't know what's going on over there. None of the what is the man? I forgot. He's a head. He's a director over there at Greenville County DSS. Man, I forgot your name. It's a very unique, different name. You mean to tell me you don't know what's going on over there? And you know they got a tracking system to tell them when they get to 45 days, you're getting close. After 45 days, you got to close that investigation, or you got to get an extension from Michael Leach or director. Got to get one. And they ain't getting them. So, y'all, we're going to pick back up. What number I say I left my phone? I'm going to get to number 30 next time. So, we're going to stop. Watch my YouTube channel. It's Clarissa Speaks the Truth, because that's what I do. And you can see more videos showing how these crimes that those judges have been committing and falsifying these court orders and letting DSS shoot anything and file anything at that courthouse, knowing these documents are illegal and fraudulent and everything else. Ain't an ounce of truth in this document. And Judge Rochelle Conits signed it. Okay? And like I said, she came out. She didn't even know. She said it had been set on the docket. On the docket now, look. She said it was set. I think I said that part. Let me read it again. Yeah, I read that matter set on my docket for an emergency protective custody. And then he said, yes, ma'am, a proper cause hearing. That's no, ma'am. Trying to be smart. Stop trying to outsmart me. It's not going to work. Y'all are busted this time. See this, FBI? United States Attorney General, Department of Justice. Can you believe this? This came from the courthouse. So we're going to pick back up. Have a good night.